Everyone, and thank you for joining us. Okay, we're all set up. There will be people joining as we go, but we're going to get started in the effort of saving time. So I am Britt Burner. I'm a partner at Burner Law Group. We are estate planning and elder law attorneys practicing from Manhattan all the way out to East Hampton in our 4 offices. And we're here today to talk about whether or not you should put your home into a trust. This is a really common question we get, and a lot of the concepts we're going to go over today are a reflection of all the things that we get asked most often. I want to say as a disclaimer that this is not meant to be legal advice. You should not act based on what you hear today. You should maybe take this information and seek your own legal advice, have a consultation with an attorney to figure out how these different concepts may apply in your situation. The other thing I'll add is that a lot of the things that I'm going to be discussing today, while they may have similar applications in other states, this is all based on New York state law, unless I suggest otherwise. It might be on federal law, but for the most part, we're going to be discussing specifics of New York state law. And so if you are in a different state, again, you should have local advice based on the laws of the state in which you live. In some instances, I'm also going to point out things that might be regional differences within the state. So, for example, living in a single family home with a deed as opposed to living in a co-op, or the difference in counties when it comes to the application of Medicaid. So we're going to talk about these different things. So again, note that this information may not apply all to you, but partially. So all that being said, just a little housekeeping. There's a Q&A at the bottom of, or likely at the bottom of your screen. If you have any questions, you can type them into the Q&A and I will go through those questions at the end of the webinar. But your question might be answered as we continue on. So I'm going to get started. Again, thank you for joining us for Should I Put My Home into a Trust? So first, I'm going to start with what is a trust. This is the biggest question I get about trust. People don't understand the concept. It is a document, first and foremost, that you sign, a trust document, and that document creates a legal entity. And that legal entity can then own things. A house is a perfect example. You have a deed to your home. When you purchased it, you were the owner of that property. If you choose to create a trust and put your home into that trust, you are signing a trust document that lays out the rules of the game. What are the rules if you're alive and you have your capacity? What are the rules if you're alive but you lose your mental capacity? What are the rules after your death? All of these things should be written out in that trust document so that we know how to operate the trust. But that's not enough. You have to fund a trust. You have to put something in it. So I create the trust document. I sign that. The creator signs it and the trustee signs it. And as you'll see, we're going to talk about today, sometimes that's the same person. Sometimes it's 2 different people or 3 different people. And then you have to fund it. So what do I mean by fund it? Well, in the case of a home that has a deed, you will sign a new deed in which you as owner of the home give the property to the trust. So instead of Britt being the owner of the home, Britt's trust is the owner of the home. And who pays the taxes and how things are handled and what happens when I die all depends on what that trust document says. So that's a really important thing to understand. I had a client once who said to me, I don't understand. What's the trust? Where does it live? What is it? And I said, well, it doesn't live anywhere, right? It can own your home. It can own a bank account. So your trust can have multiple assets in it. The bank account can be used as cash or can be kept as cash or can be put into investments that might have income. And then the trust document will tell us what to do with that income. And so it all depends on what that trust document is. So it's a very frustrating thing. Sometimes people say to me, well, can a trustee do X? And my answer is always, I don't know. Let's look at the trust document. Because while one person's trustee might be able to perform that function, another trust document might prohibit it. So it all falls into the terms of that document. It's very important. Now, I want to distinguish between a trust and a will. A last will and testament, a will, is a document that says what happens when I die. Where do I want my assets to go and who's in charge? My executor. The trust also says those things, but the big difference between the will and the trust is that if done properly, the trust owned things while you were alive. Your wishes without any court process. Whereas a will has to go through a process called probate, and that is the court process of validating that will and saying, yes, this person can be the executor, and yes, this will isn't a forgery and nobody was forced to do this, and anybody who's a direct family member isn't contesting it, or they did contest it and they lost. And then the will can be followed. So in the case of a house, if I put my house in a trust and then I die, the day after I die, if my trustee is in charge of that house and the house in the trust says the house can be sold, that trustee can sell the house immediately. Whereas with a will, if I own my house in just my name, the day after I die, my executor can't do anything. They can't do anything until that probate process is completed. And once it's completed, the executor can follow my wishes and sell the home and do the other things that I've directed. And so there can be a large time delay there because probate can take a long time. So when we talk about should I put my home in a trust, whether it's, and we're going to talk about revocable trusts, we're going to talk about irrevocable trusts. But the number one reason that I find to put a home in a trust is to avoid probate. And that's going to happen regardless of which type of trust you decide to create. That's going to stop that delay. It's going to stop that court process. Many people believe that the process of probate is avoided if you have a good will, but that's exactly the opposite. Wills must go through probate, and the word probate means the process of sending that will through the court process. So you can't have one without the other. Probate and will go hand in hand. All wills have to get probated, and probate requires that there is a will. They go together. There's no way out of it. So if you're looking to avoid probate right off the bat, you might want to do a will. Now, why might you want to avoid probate? One of the main reasons we like to avoid probate is if you own homes in multiple states. So say you own a home in New York, and that's your primary residence, but you have a secondary residence in Florida or Arizona or Vermont or wherever it is that you like to summer or winter, whichever season you hate, you choose to go somewhere else. Well, in that case, if you had all those homes in your sole name with no, just no joint owner, not in a trust, just Britt owns the house in New York, Britt owns the house in Vermont, Britt owns the house in Florida. Well, in that case, when I die, my will would have to go through probate in New York because that's my primary residence. And then we would have to do what's called an ancillary probate in both of those other states. So now I don't just have the delay and the cost of one probate, I have the delay and the cost of 3 probates. And, if anybody that's listening has dealt with the surrogates court and has dealt with probate, it is a very slow process and it's hard to speed up, as buttoned up as your documents are, it still takes time. And you're at the whim of the court, and it has gotten worse since COVID. So prior to COVID, we weren't necessarily, now if you had multiple states, we were always saying a trust, but if you just had one state, we weren't necessarily saying that avoiding probate was the most important thing. But with the way the courts have been going recently, we've been finding that it's in people's best interest to avoid probate where they can, and the hassles, the complications, the delay, and the costs. So avoiding probate for the main reasons of the costs and the time. The second reason being if you own property in multiple states. Third reason being, if you don't know who your next of kin are. So number one, people come in, they say, all I own is my home and a retirement account, and my retirement account has beneficiaries, and then I have my house. And I want it to go, but don't worry, I'm simple. That's always, kiss of death. Don't worry, I'm simple. I have no family. That is the worst case scenario in a probate situation, because the process of probate, the law requires notification of your next of kin. And as much as I try to explain to that person that they have next of kin, they keep saying, I don't have any, I don't have any. We all have them. The question is, how far removed are they from you? And do you know who they are? Do you have a way of tracking them down? So we have people who say, okay, well, I immigrated here to the United States. I was an only child. My parents are deceased. Maybe I have cousins somewhere, but if I do, I haven't seen them since I was 4 years old, and now I'm 85, and I don't know if they're alive, and I don't know if they have children or if their children have children. And then we get into this situation where, even though this individual may have wanted their house to go to their best friend or their neighbor or whatever person they have identified, maybe a charity, we're still in a situation where we have to notify all of these strangers, essentially. And if we can't determine who they are, the court makes us do our due diligence. The court makes us search. The court makes us hire a genealogist. The court makes us publish in the back of newspapers where the people are likely to live. If you've ever looked in the back of a local newspaper and you see those little square death notices, that's what those death notices are often about. They're saying that this person's will is being probated, and if you are a relative, you have a right to come to court on X date and contest it for whatever reason. Whether you'll win or not, that's another story, but it doesn't mean that it can't slow the process down. So again, if you don't know who your next of kin are, that's a reason to avoid probate. Another reason to avoid probate is if you're disinheriting one of your next of kin. Take the most simple of situations. I know I have 2 children, but I also know that I want to give everything to one and nothing to the other. Well, the one that I'm giving nothing to is required to sign off on the probate of my will, or at least to be given notice that my will is being probated and given an opportunity to come to court and be heard as to why it shouldn't be probated. And so if I'm disinheriting somebody who has that right, I probably don't want to go through probate, because I don't want, again, the cost, the delay, the complications, the headache to my other child of the person coming in and trying to get something from the estate, even though I left nothing to them. And even if your will says I specifically leave nothing to child number 2, they still have rights under the law. And so again, if you're disinheriting one of those people, you want to think twice about probate. And if your home is one of your assets, you likely want to put your home into a trust. The other reason that we often like to create trusts to avoid probate is if we have disabled beneficiaries, because in certain circumstances, the court will appoint additional persons to represent the interest of the disabled person. And again, it can be time and money. So that's likely a reason why we might want to avoid probate. So just to recap, we often create trusts and put property into trusts to avoid probate for the purposes of the time and the money of the delay, the having property in multiple states, having a disabled beneficiary, having unknown heirs, or disinheriting one of your heirs. Those are the main reasons that we like to avoid probate, and we like to put properties into trust. All the trusts that I'm going to talk about today can be created as what we call grantor trusts. That is a tax concept. And the idea there is I'm the grantor, meaning I'm the creator of the trust. I'm putting my property into the trust. And the properties in the trust are mine for all tax purposes. So for capital gains tax purposes, for if I decide to sell it from the trust, For income tax purposes, if I rent the property and I get the income from that rental, that is my income. And also for property tax purposes. So in terms of if you have a veterans exemption or a senior citizens exemption from your taxes, all of that will still apply with all of the trusts that I'm talking about today. Now, I want to talk about home ownership. So when you own a home, and certainly if more than one person owns a home, you can own a home in multiple ways. One way is joint with right of survivorship. So I may own a home with a family member, let's say my sibling and I own a home together, and we chose to make it joint with right of survivorship. The deed has to actually say joint with rights of survivorship in that instance. So let's say my sister and I own this home. The deed says we own it joint with right of survivorship. That means if one of us dies, the other is automatically the sole owner. So if my will says I give my half of the property to my cousin and I die first, nothing happens for my cousin. Everything goes to my sister. That is the controlling interest. And then when my sister subsequently dies after me, her interest, which is now 100%, will pass on according to her will. And all those other things we talked about will apply, but that's what joint with right of survivorship means. And it has to specifically say that. If it said nothing, if it said my name and my sister's name, and that was it on the deed as owners, the default is what we call tenants in common. That means I own 50% and she owns 50%. So if I die, my 50% will go through my will and go to my cousin the way I designated. And now my sister owns a property with my cousin. She doesn't get the whole thing. And that is the default if it doesn't say anything else. There's also something called tenancy by the entirety. Tenancy by the entirety is only between spouses. Only two spouses, legally married individuals, can own something tenancy by the entirety. And that is essentially the same thing as joint with right of survivorship. When one dies, the full interest goes to the other person. A lot of times our clients own properties and they might have bought them 30 or 40 years earlier, and they don't really know how they own their properties. And so, for example, I may have a couple who comes in, it's a second marriage. They've been married for 40 years and they own the property tenancy by the entirety. Why? Because they were husband and wife, or wife and wife, husband and husband. They purchased a property as spouses, and they might be in a second marriage and have different children from the first marriage. So their intention might have been, or they probably didn't think about it at the time, you know, young newlywed couple buying a property, wasn't thinking about what's going to happen when we die, but they might not realize what they've done. By not specifying it as tenants in common, because the default as married people is tenancy by the entirety, what they've essentially done is they've said, when I die, everything goes to my spouse. And so then when my spouse dies, if their will says everything goes to their children from their prior marriage, my children got cut out. And it's not necessarily because of bad acting on anyone's part. It might have just been not realizing the ownership of the home. And so a lot of times when we have these people coming in, we start with, okay, let's see what your deed says. How do you own this? Do you own this 50-50, or do you truly own it with these rights of survivorship in a way where the survivor, maybe not realizing it, could be cutting out the children of the first person to die, or the beneficiaries? It doesn't have to be children from a first marriage. They could just intend that half of the property go to one person's family and the other half go to the others. So it's very important not just to make sure that your will, your trust all say what you want it to say, but also what's the ownership of the property. So let's say somebody does have this situation and they're not worried about Medicaid. They just want to make sure my half of the property goes to my people, your half of the property goes to your people. Well, if they each create a revocable trust and they each put their half of the property in the revocable trust, then upon the death of the first person, you can say something like, when I die, my house stays intact. My spouse can keep living in it. They own the other half of it. They can be there forever. They can do whatever they want. They're responsible to pay for it. But when my spouse dies, my half goes to my beneficiaries, whoever they may be. Sometimes it's charities as well. And then same thing for the surviving spouse's half at their death, their half goes to whomever their beneficiaries are going to be. And so sometimes putting a home in a trust is a way to make it very clear how you want that property split when there's multiple owners. I want to point out specifically something about co-ops. If you purchased your co-op as spouses before 1996, you do not own it tenancy by the entirety. You own it as tenants in common. Because the ownership of a co-op is actually stock in the corporation and a lease on the unit, it wasn't the same type of ownership. And in 1996, there was a clarifying law that made it clear that two spouses should own that as tenancy by the entirety. But I'll give you an example. We have a case right now where the two spouses' names are on the stock certificate. It is silent as to ownership. So you would think the default would be tenancy by the entirety, but they bought it in the 80s. And since they bought it in the 80s, that law wasn't yet in effect. And so they own it tenants in common. And so now the first spouse died, and we're going to have to probate the first spouse's will in order for that half of the property to just go to the survivor. And so that there's a lot of complications that go into that, capacity of the survivor, time, will the survivor still be alive? They're infirm themselves. And so those are the things we're concerned about. Had these individuals either owned a tenancy by the entirety or each put their half into a revocable trust, we would be avoiding the court in that regard. And again, that's 1996. What I have had some people do, some co-ops don't allow ownership by trusts, but at the very least, just getting the stock and the lease changed so that the ownership is proper and what was intended might be a way to do it. So if you're in that situation, you should definitely be seeking legal advice about how to make those changes. So we talked about all of the types of ownership. Now I'm going to talk about what a revocable trust is. So a revocable trust is a trust that can be revoked. It can be changed, amended. If Britt is the creator of the trust, Britt can also be the trustee of the trust. I manage it, I control it. It has my social security number. I can do whatever I want with it. I can change the trust terms at any time. I can do anything. Then I can say, if I become incapacitated, this is who will be my secondary trustee, my backup. And then when I die, also say who will be the trustee. They can be the same person, but in certain circumstances, they are not. But in a lot of cases, they are. So a revocable trust really doesn't change anything except that ownership. It's otherwise fully my property, and nobody really controls it except for me. I just do it with my trustee hat on instead of my individual person hat. And again, like with the next trust I'm going to talk about, this is tax neutral. So there is no issue with the revocable trust as to the being treated any differently for any kind of tax purposes. This is going to avoid probate and for all those reasons that we talked about. And make it so that there is a trustee who's in charge of your estate without having to involve a court. The other type of trust we're going to talk about, and this is one that comes up a lot for our clients and is often appropriate, but sometimes not, is an irrevocable trust for Medicaid asset protection purposes. I call it that because there are many types of irrevocable trusts. An irrevocable trust is a very broad name, and it really just means it's a trust with some type of limitations as opposed to the revocable. So it is a very broad category, but specifically here, we're going to be talking about the Medicaid Asset Protection Trust. It is, again, for tax purposes, all belongs to the grantor, the creator. Now, in this type of trust, it's different. I might be creating it and putting my house into it, but I can't be the trustee of it, nor can my spouse. So I can name my child, I can name my friend, I can name anyone I want, but it can't be me and it can't be my spouse. The purpose of creating this trust is because you want to make it so that at the point that you may apply for Medicaid to help pay for the costs of long-term care, either at home or in a nursing facility, that your home is not counted as an asset. And also that after your death, Medicaid doesn't put a lien on the property to recover from it. That's why you do this, right? So if you're someone who has assets and income that are so much that you don't think you'll ever need the program, then you wouldn't even be considering a trust like this. Or somebody with, an enormously high income and an enormously high long-term care insurance policy, they may say, this is too restrictive. It's not worth it for me. I have these other ways of paying if I need care. And so whether or not this Medicaid planning is appropriate for you is going to be very person specific and very fact specific. A lot of times I have people who come in and they think this is what they want. And when I start to explain it, they may realize, well, I don't have children. And sure, I would love for a little something to go to my niece if there's anything left. But first and foremost, I want control. And if it's not a goal of theirs to save and shelter these assets so they can pass on, then what you have to give up for it might not be worth it. On the flip side of that, I have a lot of clients who say, well, there's a lot of flexibility here and I don't really need that much more control. And I feel comfortable with the terms of it. And I'd be really happy to save these assets to pass on. Then that's the person who this is an appropriate plan for. So the trust by its terms is irrevocable. So that means you can't amend it or revoke it. You can't do so on your own. There is a provision of New York state law that says that if you can get all of your beneficiaries to agree, there are ways that you can end the trust, revoke it, amend it, but that's very complicated. And we don't like people to go into this assuming that that can be done. That's really only in the case of an emergency, if we're really looking to reverse the Medicaid plan, that we do things like that. But for the most part, this is an irrevocable trust. It must say that income can go back to the grantor, to Britt, but principal cannot. So what does that mean? So let's say I have a house in the trust and I rent it out. Well, if I rent it out, I can get the income from that rental. That's mine. I report it on my income tax returns because it's a grantor trust. But if I decide to sell the property and then let's say it was worth $500,000 and that $500,000 is now in a bank account in the name of the trust, I can't have that $500,000 and it can't be used for my benefit. It can't be used for me even by the trustee. So again, that's the little control part. That's where you're giving up something because you don't get anything for nothing. So if you're looking for the Medicaid protection, you have to give something up on the other side. Now, as the creator of the trust, the grantor, you can keep the right to change the trustees and you can keep the right to change the beneficiaries. So while it isn't something that you can amend or revoke, there are certain provisions that you have rights over. And trustees and beneficiaries after your death are two examples of that. You are responsible for the upkeep, the maintenance, etc., of your residence. So if I'm living in my primary residence and I've put it into one of these Medicaid trusts, then I have to pay the taxes. I have to pay the insurance, the utilities. If I need a new roof, that is on me. That is not on my trustee. Because remember, my trustee cannot use principal to benefit me. And therefore, the money in the trust can't be used to keep up the property. So you don't want people to put everything into the trust because then what do they live on? So you have to be very balanced in your approach to make sure that the plan is going to work long-term for the individual. If you decide to sell the house in the trust, so that can be done as well. Your trustee can sell the house. The money is then in the trust. It can be left in, but there will be a trust bank account that's opened by your trustee. The proceeds of sale would go into that trust bank account. And then the trust can be used and can buy and sell other assets. The assets can be invested. If they're invested and there's interest and dividends on that investment account, that is your income. You can take that because you're the creator of the trust And that gets reported on your tax returns. You don't have to put into the trust that the grantor gets the income. That is the most common type, but in certain cases, we make it so that the grantor is not entitled to the income. And that's really going to be incredibly fact specific for the individual circumstance. Capital gains tax. So quick primer on capital gains tax. If I buy a house for $100,000 and I sell it during my lifetime for $1 million, I have a $900,000 gain. I plus my spouse, we each have a $250,000 exemption from capital gains tax. So that takes my $100,000 is what I bought it for. I call that my cost basis. I add the $500,000 in exclusion because it's our primary residence. I'm now at $600,000. And let's say I put capital improvements in of another $100,000. I'm now at $700,000. Then if I sell it, I'm selling it for a $300,000 gain. And I pay capital gains tax, state and federal, on the $300,000 worth of gain, if it's my primary residence. That stays whether it's in the trust or not, because it's a grantor trust, so you retain the right to get that. Also, if I die and I still own the property, it gets a step up to my date of death value. So that means if I die and it's worth $1 million, the fact that I bought it for $100,000 gets wiped out. It's irrelevant. And if it's $1 million at my date of death and it's sold for $1 million, there's no tax because there's no gain, because I got that step up at date of death. That is the same whether it's in my name, a revocable trust, or one of these Medicaid asset protection trusts, if drafted properly. So that remains in all these cases, because again, this is a tax neutral trust. A lot of people get concerned that they're going to lose their veterans exemption, their star exemption. They're going to lose their $250,000 exclusion if they go to sell. All of that remains. You are not losing that right. And that's really important to people, especially as they're on a fixed income as they get older. And then at my death, they can say, again, my trust continues for the lifetime of my spouse. So the spouse can continue to live there or continue to collect the income if I want them to. And then it says how it should be distributed. So just like the will, maybe I say my house is sold and the proceeds are distributed to my 3 children. Maybe it says the house should be sold, but my one child has the right of first refusal, meaning they have the right to buy out the others and they have the first right to it because they've lived with me so long and I want them to have the opportunity. Maybe the child has lived with me for so long and I want them to be able to live there for as long as they want, as long as they can afford to. So maybe I create a residence trust and my trust says, when I die, my child can keep living there as long as they pay the maintenance and the upkeep. And then upon their death, or if they don't want to live there anymore, then it distributes out to my other beneficiaries. I can say it just goes to my 3 children. I have someone right now who has a very valuable property on the East End that they use as a rental for part of the year. And so the idea is that when the parent dies, the assets are going to go into a trust where one of the 3 children, the one who's local, can manage the property and make sure that the bills are paid on it and collects the rents and all of that. And then they'll share in the income from the property. And then if the property's sold, they'll share in the proceeds. But while they decide to keep it running, we've left one trustee who's in charge of doing that, rather than the confusion of having multiple people have their hand on it and be in charge. And again, we have the benefit with all of these trusts, both of these trusts, of avoiding probate, avoiding the court, avoiding a situation where we have nobody in charge of the property. I've had properties where someone's knocking on the door and wants to buy it, and the person says, I'm not officially the executor because I haven't been appointed by the court, and I can't even enter into a sales contract with you, even if we waited to close. I've had co-ops where we're waiting on probate and the co-op won't even let the executor in the building. So, no one's cleaned out the refrigerator. Nobody has started to clean out the property. And this is a delay on sale. And they might be paying or racking up a bill for $1,500 a month of maintenance for the building. all in an apartment that there's nothing they can do about until probate is completed. So even if you're in a situation where you're not worried about Medicaid, you might still want to do a trust for your primary residence or for your secondary or whatever the property may be, because you may want to avoid probate, to avoid that delay and those costs. And the costs do go beyond attorney's fees and court filing fees, because again, with a house, someone's paying the taxes, someone's paying the oil. You know, I have a property where I'm the executor, and it took a while to get appointed by the court, and we didn't know who was checking on the boiler. I didn't legally have access. We luckily were able to take care of it, but you can really have a lot of damage on a property when it just sits there untouched by anybody. So those are the main reasons that we like to put a property into a trust. Here and see what they are, and if they're anything that were not answered. Should a taxable account have beneficiaries in order to avoid probate? So that's not exactly about a home, but the same kind of concepts apply. Whether or not you should have beneficiaries, you know, if you have tax deferred retirement accounts, IRA, 403B, TDAs, those things, yes, those should have beneficiaries. As to all other accounts, you should be getting advice as to whether going the beneficiary route makes the most sense for your estate, or if you want to do some other planning, like putting those assets in a trust or something. But yes, retirement tax deferred accounts should have beneficiaries named on them. Where do you get a copy of the deed? So, you know, in your local county, if you are in New York City, there's an online way to look, actually right from your own living room. It's called ACRIS, ACRIS. Anyone can use it. It's not attorney specific. And you can go on and you can search by name or by the address, and you can determine, I forget the year that they started putting documents online, but most deeds can be found by going onto ACRIS, and you can also see if there's mortgages on the property, etc. If your deed is from before they started having ACRIS, you can go to the New York City Department of Finance. Borough Hall in Brooklyn is where I've gone for deed search to the record room. We often get searches. We have a title company pull the deeds when we're looking for them, but the different counties is the answer to that. Also, you know, if you ever get something in the mail that says, you know, pay us $100 for a certified copy of your deed, you know, deeds, because they're public record, you don't really have to pay someone to do it. You could get it yourself. Now, you might want to for convenience sake, but people get very nervous if they lost their deed, but it is public record, so you don't have to be worried about that. So the question is that someone has an irrevocable trust and was on home care Medicaid, and her income through a pool trust was used to pay the bills. That is proper. Now she went to a nursing home, and her income all goes to the nursing home, because that is what happens with Medicaid, and the home expenses are being paid by the trust. That is not a good thing. So the property, the assets in the trust should not be used. Now, there might be nuances of your situation that make it okay, but I would say my blatant answer without knowing more and giving specific legal advice would be that generally we don't like to do that. If you leave the interest in the trust account, who pays the income tax? That's a really complicated question. It depends on how the trust is drafted. And I would say to talk to the accountant about that. We want to draft trusts, and when we pay out income in a way where we want it to be the grantor that pays the tax, because trusts, when they are forced to file for income taxes and when they are forced to pay income taxes, pay in the highest tax bracket at a very low rate, at a very low threshold. So we don't want the trust to have to pay the taxes. So generally, if you have a properly drafted grantor trust that's treated properly, then it's the grantor who pays the taxes. So does your will get probated even if the property is owned by two people with right of survivorship? So it won't get probated at the first death. It will get probated at the second death. So if you're joint with right of survivorship, person one dies, person two owns the whole property. The problem becomes when person two dies, their will would have to be probated if something else was not done. Capital gains tax the question is it determined according to federal or state laws? It's both. There's a federal and there's a state capital gains tax in New York. I think when you add them together, they're probably somewhere around, I think it's the highest, it could be around 33%. So, I want to add to that. So when people come in and they say, I'm worried about Medicaid or I want to avoid probate, so I'm going to give my house to someone. We don't want them to do that because let's say I want everything to go to my daughter. So I give her my house while I'm alive. My daughter forever has my $100,000 when I bought it cost basis. She doesn't have my date of death basis. After I die, she has no step up ever. So it could incur a really large capital gains tax when she sells it. Also, if it's no longer my house, I can't get the real property exemptions for it being my primary residence. So I can't get the star exemption if I'm entitled to veterans, etc. And if I sell it while I'm alive, we can't get my $250,000 exclusion from capital gains tax. So we don't like to just give properties over to someone else for that reason. This is a question about the estate tax present amount of money. So this year in New York State, it's $6.58 million. So if you as an individual have less than $6.58 million when you die, all in, everything in, then there's no taxes paid. Can you put a property that has a lien in a trust? It depends the lien, but usually you can, like, for example, if somebody has a mortgage on their property, there's certain laws that protect it to allow you to put it into this type of trust. But it's going to depend on the specifics of the situation. It says, do you have to put all your assets in a trust or can you pick and choose? You can pick and choose. So for example, especially with the Medicaid planning, someone may say, I'm going to put my home and $100,000 in the trust and protect those, but I'm going to leave everything else out of the trust and I'm going to control it myself because I don't know if I'm ever going to need Medicaid, but I want to start my planning. So you can certainly pick and choose. And we generally recommend that be done when people are doing advanced planning. Okay, someone asked me to explain again about grantor trust. So a grantor trust is an IRS concept, and the grantor is the creator of the trust. So if I'm creating a trust and putting my assets into it, I'm a grantor. And if it is drafted properly as a grantor trust for income and estate tax purposes, that's how I'm entitled to the income, and I report the income on my tax returns. And that's also why I still get the 250 step up for if I sell, or the 250 exclusion if I sell the property during my lifetime. And it's also why I am able to get the step up at my date of death. And that's a drafting consideration to make sure it's drafted properly. So can a deed have more than 2 people with joint right of survivorship? It can. It could have 10 people joint with right of survivorship, and until they all die off, there's one left. But there's, again, that's going to be a specific situation, pros and cons of that, if it's going to make sense to do it. But there is no limit on how many people can be joint with rights of survivorship. There's a question about how do you prove capital improvements on the home? That's really an accountant question. I know that I've been told by accountants that, you're more attesting, as in you're, swearing that this is, you're representing properly what was done, but I'm not sure if audited what they would actually look for. You'd have to ask an accountant because they're the one who generally, while we can give you the ideas about capital gains tax and how to preserve those rights in the trust, in the end, the accountant is the one on your income tax returns for the year in which you sell. That's who's determining what the capital gains tax is that should be paid by the government. So I would ask an accountant that question. Typically, how long does probate take? I would say my answer to that is there is no typically. Every county is different. Every case is different. And there's not really much rhyme or reason. There's ones that I thought would be relatively simple that have taken 8 months, 10 months. There's ones that are more complicated, those are going to take longer. But it has been in New York State, particularly downstate, incredibly slow. I have a client who her father died in New Jersey, and she was able to go through probate in New Jersey in about a week. But now he owned properties in New York. We're doing the ancillary probate in New York in Kings County, which can be one of the most difficult and slowest counties. And my guess is that the Kings County one might take close to a year. And it was just a very short period of time in New Jersey. So it's very different in each place. So someone said that means I can have a will, but also set up a revocable trust just for my co-op. What should be stated in the will? So generally speaking, if somebody does a trust, I would suggest avoiding probate on all the other assets. You cannot, so avoiding the will. Generally, if you have a trust, your will is going to be what we call a pour over will. It's going to say, if there's anything in my name when I die, pour it into my trust. But our goal is going to be not to probate that will. So each asset should either have a beneficiary named on it, a joint owner, or be in your revocable trust. And we would go, if we're working with someone, we go asset for asset and make sure that everything makes sense the way it is. But generally, the will is going to be a pour over will. So someone's asking about LLCs versus trusts and investment properties. Usually what a lot of clients do, like say someone has 5 commercial properties with tenants in them, they would have 5 LLCs because you want to limit the liability to each building. So we would recommend having 5 LLCs and then assigning the LLCs to the revocable trust. So upon your death, your revocable trust is determining what happens with those 5 LLCs and is all managed by your trustee. However, we're still keeping the liability separate for each property. Does a pour over will need to be probated? All wills need to be probated, regardless of what they say, if you have assets in your sole name with no beneficiary. So if you've properly put everything in your trust or named a beneficiary, then there will be no probate of any will. But if you have straggler assets or you didn't do a trust and you never named beneficiaries, then all wills are probated in those circumstances. So if you sell your house in a trust and the money goes into a trust bank account, who has access and what are the limitations on that money? So this is where I give my annoying answer of it depends what the trust document says. If it's in a revocable trust, full access. You can do whatever you want with that money, no questions. If it is in an irrevocable Medicaid asset protection trust, then the trustee is the one that determines what to do with those assets. So the trustee determines if they're going to invest them or leave them in cash, etc. There can be individuals that are named as lifetime beneficiaries of principal other than yourself and your spouse. So for example, if I am a single person and I have 3 children, 3 adult children, they might be my lifetime beneficiaries of principal. So they may be able to get the money out of the trust and then it becomes theirs, but it can't come to me because in a Medicaid asset protection trust, if it's used for me, it's not protected. And if it says it can use it for me, it's not protected. So there's a question about, after divorce with one person now on the deed, what is the date of value for cost basis? I think that it would be the original purchase price because the transfer, it would kind of depends on I think it would be only if you purchased it. If you bought out your spouse, if it was done and structured in that way, then that would be the cost basis. But if it was not purchased out from the spouse, then it would be the purchase price, original purchase price, I should say. So a revocable trust does not protect the home for Medicaid purposes. That is correct. The irrevocable Medicaid asset protection trust is what is going to give certainly that nursing home protection. In terms of home care, and this is going to differ based on what county you're in, but in certain counties, you want to, even if you only do a revocable trust, you want to put your property into the revocable trust to avoid probate, to avoid the Medicaid lien at your death, even if you were only receiving home care services. But the revocable trust will not give you any protection in a nursing home circumstance. Look back period. So there's currently no look back for home care Medicaid. However, there is a look back for nursing home Medicaid. So what that means is if you need a nursing home and you want Medicaid to assist with paying for the care, they go back 5 years and say, what did you give away? If you gave your house to a trust, if you create one of these trusts and did the deed over within the 5 years, there's going to be a period of time that Medicaid will not cover the cost of your care. So the goal is to get the property into the trust and allow 5 years to elapse before needing it, and it would be not counted as an asset for eligibility. That could change, and that would not change until April of 2024 or later, in which case there may end up being a 2.5-year look back, but that is not currently in play. If the trust can't pay the home expenses, how should the expenses be paid? Often they're paid by the individual if they have their own money. If they don't have their own money, even somebody who's on Medicaid this year is allowed to have $28,000 in assets. They can be paid from the assets of the individual, or they can be paid by, other family members or potentially someone who's going to inherit the home down the line. And sometimes if there's no one to pay the expenses, it requires that the home be sold. Someone asked, in addition to what's the look back, at what age should you set up an irrevocable trust? It's hard to set an age because everybody is different in terms of when they feel comfortable giving up some level of control, and also when what their health status is, et cetera. And so I don't think there's a set age. I think it's a hard thing to think of someone who is still actively working and earning, et cetera, to do this type of planning, but it's hard to say. It's really dependent on the situation. Okay, so the question is, when someone dies and their house is left to their adult child in the trust, does the child leave the house in the trust, or do they take it out and create their own trust? The answer is it depends what the trust document says. So very often the way we draft trusts is we say, okay, when Britt dies, Britt's house goes to Britt's daughter in a trust, and then lays out the terms of that trust. And it can create creditor protection. It can create nursing home protection, et cetera, for my child. And so that's one option. The other option is I could just say my child gets it outright, and then it's just signed over from the trust to the child individually. But it depends on what my wishes were when I created the document, and therefore what the document says. And how does capital gains tax apply to the scenario? So that child, regardless of how I wrote it, got that step up in cost basis to my date of death value. So if it was worth $1 million when I died, whether or not they get it outright or in a trust, that's the new cost basis for the property where they inherited it. I think somebody's asking here, is it more beneficial for a 60-year-old with several properties to use, they said a grantor trust, but I'm assuming they mean a revocable trust rather than an irrevocable, so she can maintain more control. So again, revocable or irrevocable, both the trusts we talked about today are grantor trusts. But yes, you do retain control with the revocable. You don't give up anything with the revocable, really. And so therefore you don't have any protection, but you're not held back. And so if you want to control those properties and you're not particularly concerned about Medicaid, then yes, a revocable trust is likely going to be the best thing in your scenario. House expenses can be paid through an owner's pension. It's the second part of this question, or is the whole pension sent to the nursing home? So if there's no spouse at home, if there's no spouse in the situation, then all of the income, pension, required minimum distributions, trust income, Social Security, et cetera, goes to the nursing facility, and Medicaid pays the balance. And so none of that income is available to pay home expenses. If you add your spouse to a deed, with right of survivorship, or remember, if it's a spouse, it's its tenancy by the entirety. The original purchase price is the tax basis for both of you. However, when you die, there is a step up in cost basis on half of the property when the first person dies, and a step up in cost basis on the other half of the property when the second person dies. So that's a much more complicated tax basis when sold at the second death, because you actually have two different sets of tax bases if the trust or if the property has changed in value from the first death to the second death. So this is asking if you're selling your home and moving into a condo, will the trust have any bearing on the new residence? So in certain circumstances, we allow for a trust to buy a replacement property. So it can be that one property is sold out of the trust and the trust buys new property. And again, that's going to depend on the individual terms of the trust and if that is allowed or not. And the last thing I'll just answer quickly is, can retirement assets be put in a trust? So 401ks, IRAs, all those things will not be placed in a trust. There might be certain situations where it makes sense to have the trust for a beneficiary if they're disabled or have creditor issues, be the beneficiary of those accounts, but you have to maintain ownership, because you can't, if you change ownership, then it's seen as a taxable event. So we do not change ownership, those stay in your individual name. I want to thank everyone for joining us. We will be assuming that the recording works out okay, technologically speaking. This will be posted on our website, and I look forward to seeing any one of you in the future. Thank you so much for joining us, and have a great day.